I've been to court several times. These are some of the rare questions I've been asked, so I didn't come and I didn't expect this to happen.
Do you have an idea which year you were instructed to case review this matter?
Oh yeah, my lord, I actually came with my response to that letter, which is here. So,
go ahead.
My lord, I responded to this letter on 3rd July 2024.
3rd July 2024.
Yeah.
From your response, you are in position to tell when you were instructed, because you are responding to it.
Yes.
When were you instructed?
I believe it was in April.
Please don't believe. Does your reply contain proper information to what you were being requested?
I have the reference.
And if I'm taking you so fast, please ask me to. I always advise, so this is not a battle between me and you. This court just likes to get information.
Yeah, my lord, I don't have that exact date when the letter was delivered to me. But I have the reference and I have the date in which I replied, and I'm sure that letter can be available.
You can get it. Okay.
That's right.
Can we for now have your reply? My lord, can interpretation take place?
Gambire China ekyandiko ekyahiroho ebiri omu kyandiko kyekyakozere ekyandiko eky'ensi eya heru eya US oba United States baitu byebyahandikire abimanyire kuyaho takubijuka saha eno.
Then return. So, Doctor, apart from, I'll come to this. So it is here. We want you to tell this court in what capacity you were instructed. In other words, were you instructed as a consultant or as a civil servant? As a private consultant or a civil servant?
My lord, that time I had already retired from the civil service. So I was consulted as a retired pathologist, forensic pathologist.
What were your terms of reference?
My terms of reference were basically to review the post-mortem report of the late Henry Katanga.
To review the post-mortem report of the late Henry Katanga.
That's right.
How many reports did you author in general? And by reports, my lord, I mean how many opinions did you issue in respect of what you were requested to do?
My lord,
By how many I require a number, please.
I could have explained,
No,
but 3.
3. When was your first opinion?
That one in your hand.
Very good.
Which one?
This one
The
dated,
letter. That one.
my lord,
Yes.
it's not a letter. It is an opinion.
Is it, just a moment, is that the response to the instruction?
My lord, is not a response. I have asked for how many opinions this question is about opinion now.
Because he's
Yes.
saying the one in your hand. So
Yes.
what is that?
He is describing this as an opinion, my lord. My question is, how many opinions did he issue in respect of the request? And his answer is that the first one is this in my hands. And I think he's right.
So what do I record? It is the what?
My question is on opinion. This was your first, confirm that this was your first opinion.
That's right.
On the
my
matter.
lord.
So
That's
did
right.
I record that the first opinion is contained in the response to the instruction?
Please,
what do I put?
Yes,
clear, go.
this response,
Yes, is the first opinion.
yes, in response to the instructions I received.
This is the first opinion. My lord, are we together?
So I've recorded that the first opinion is contained in the response to the instructions.
Good. When did you issue your first opinion in response to the request for review?
On the 3rd of July,
Which year?
2024.
Okay. Return it. We pray to tender his first opinion as prosecution exit. Yeah, you already have it. As a prosecution exit.
Is that it and not? PE 140. So at 128. 128.
Dr. Ozivuwa, when did you issue your second opinion?
My second opinion is the one which has been taken in, which I signed this year.
For avoidance of doubt, may we pray for Maybe Defense Exhibit 28. May we, my Lord, just for avoidance of doubt, be clear. Defense Exhibit 28.
You want it?
Yes, my Lord.
Bazirezo anti badde tebannazireeta zetuteekako.
From the Zira Women Prison. I don't know.
Proceed, my lord.
That during cross-examination, the DW2 was asked questions about his retirement, his appraisal, and why he was still occupying physical office space at a government institution even after his retirement. It should be noted that during his examination in chief, Dr. Ozivuwa testified that he retired from government service in December 2023. The defense cited sections 145, 147, 2B and C, 148, 149 and 150 of the Evidence Act in support of their assertion that the questions the prosecution was putting to the witness were insulting, indecent and scandalous and aimed at injuring the person of the witness. Jumps to the evidence of the witness. Section 145 of the Evidence Act provides that when a witness is cross-examined, he or she may, in addition to the questions hearing before referred to, be asked any questions which tend to test his or her veracity, discover who he or she is and what is his or her position in life, or questions to shake his or her credibility by injuring his or her character, although the answer to those questions might tend directly or indirectly to discriminate him or her, or might tend directly or indirectly to expose him or her to penalty or forfeiture. Section 147 provides that court will decide when questions shall be asked and when the witness shall be compelled to answer. That is section 147.1. Section 147.2 provides for when court shall use its discretion to disallow certain questions, and these are instances where such questions are improper if the imputation which they convey relates to matters so remote in time or of such a character that the truth of the imputation would not affect or would affect in a slight degree the opinion of the court as to the credibility of the witness of the matter to which he or she testifies, or such questions are improper if there is a great disproportion between the importance of the imputation made against the witness's character and the importance of his or her evidence. Section 150 of the Evidence Act prohibits indecent and scandalous questions, while Section 151 of the Evidence Act prohibits questions intended to insult or annoy. 12th edition of the Black's Law Dictionary defines scandalous as grossly disgraceful and disreputable, inducing condemnation or reprobation by reason of flouting minimal standards of and propriety. To annoy simply means to irritate, bother, or disrupt someone's peace of mind and make them unhappy. Determination of the objection. Court has looked at the following. DW2 testified that he is a pro bono lecturer in Makerere University, Department of Pathology, having retired from civil service in December 2023, and that he sits at B27, Department of Pathology, College of Health Sciences, Makerere University. In cross-examination as provided by Section 145 of the Evidence Act, questions can be put to the witness to test his veracity, discover who he is, and also check his credibility. However, as provided in Section 147.1, court will decide when questions shall be asked and when the witness shall be compelled to answer. Section 147.2, which has already been referenced above, offers guidance to court in determining when questions shall be asked. Court is required to make a call on whether the question impacts on the witness's credibility and his character in relation to his evidence. Considering the above provisions of the law, it is the ruling of this court that in all questions put to DW2 in cross-examination, the prosecution is required to demonstrate that there is a nexus between the importance of the imputation made against the witness's character by the question and the importance of his evidence. That will help guide the court in determining.
Most of that is still bound by the Ozivuwa last Wednesday.
That's right, my lord.
And just to set the record clear from our viewpoint, by reason of prosecution exhibit 129, if it may, I use for point 129. You received the postmortem, the sole document supplied to you, which is the postmortem report in that exhibit on the 6th June 2024.
That's right, my lord.
He can't object.
Just a moment. What is the objection?
The objection, my lord, is that what the witness said he received in October 2025 were the soft copy pictures, not the additional documents. But now my colleague is saying the witness testified that he received all the other documents in October 2025.
He said on the phone.
On the phone, what he received, my lord, were pictures. That's what the witness said. The soft copy pictures, not all the additional documents, the disclosures. So that's my lord, the record I want to correct. It's factual. The witness never said that he received all the additional documents on the 25th of October 2025. What he received and what he said, what he received in October 2025 were the soft copy pictures and they are on his phone. But the additional documents, he had received them earlier after his first opinion. That's what he said.
This particular section, he mentions it shortly after, if we have to go by the letter of instruction after it was tendered in, and then this indicated that he retired in 2023, and then when we move further, he said, I verbally asked for documents from Mr. Katanga, disclosures from the DPP, and the color photographs. 2 box files were delivered to me by Mr. Katanga, and soft copies were sent to me on my phone. That's what he reported.
Not on the same day. Not on the same day. Not on the same day. That's not what it says.
Okay, my lord, you may guide us on the record.
When I was first instructed, I deemed that additional information was relevant for his first report, PX128. I nonetheless went on to form an opinion even without the additional information I considered relevant.
Ruling, if you wish or have reason to change from your earlier position. So, you first received these photographs of the deceased on the 9th of October 2028. Your first report dated 3rd July 2024, you did not have the photographs.
No, my lord.
Okay. Now on this question,
I said City Mortuary.
is different from Mulago Mortuary, correct?
Correct, my lord.
Mulago Mortuary is managed by Mulago National Referral Hospital, correct?
Correct, my lord.
By the Kampala Urban Authority, KCCA, correct?
Correct, my lord.
So it is correct to say that these two entities, though all located in Mulago, they are run under distinct managements, correct?
Correct.
Last time, or is advised.
Sorry.
Worked for the KCCA or the Uganda Police. Have you?
No, my lord.
Who appointed you to head City Mortuary?
The Department of
Department doesn't appoint, individuals appoint. Mr. Kabeka, allow me to proceed. My lord, I'm not gagging the witness. I am the one asking. Mr. Kabeka cannot determine how I ask, my lord. I am not gagging. I am just guiding the witness to precisely answer my question. So when he says it,
he should relate the answer to be on record. Then he can rephrase and put another question, but not to stop him from giving his answer.
my lord, I'm to what we were telling him to. You know?
Mr. Moses,
No,
ask you.
Yeah, let me ask him. Please humbly allow us to cross-examine. Please, doctor, if you feel that my questions are unclear or I am being unfair to you in any way, please raise it to the court. Okay? Raise it to the court. We have full confidence that you carried your abilities to this court. Okay? So, the question is, who appointed you? And I'm referring to an individual officer in whichever capacity that signed your appointment letter.
My lord,
Can you explain that to me so that you can explain?
my lord, it would be prudent for me to explain.
Mr. Ozivuwa, who? The question is clear. Who? Do you know who appointed you?
Mr. Morgan, you want the witness to answer exactly who appointed?
My lord, that is the question. I'm not asking for explanations.
Doctor, perhaps you can state that you were not appointed by an individual.
Maybe.
That's right.
Yes.
I was not appointed by an individual, but voted by the pathologists.
Whether you have any instrument appointing you to head that government facility called City Mortuary. Do you?
We have never had instruments.
Please.
Yes, we don't have instruments. In my experience there, in the Department of Pathology, we would just ask somebody to head. That's right.
So who chaired that meeting where you were?
Yeah.
Was it in a meeting? Was it in a conference?
That's right.
Who chaired it?
Professor Bimenya, Gabriel Bimenya. I headed from around 2008 to about 2013.
Are you familiar with somebody called Dr. Barunji?
That's right, my lord.
Did you work with him?
That's right, my lord.
Where did you work with him?
I worked with him in the Department of Pathology, Makerere University.
From 1980 up to the year 2011. Is that a fact in your knowledge?
No, it's not a fact.
The mortuary between that period, 1980 and 2011.
Yes, I do.
Who headed the city mortuary?
Dr. Nsereko Kasa, from whom I took over.
He has been the head of the city mortuary from 2011 to date.
That's not right.
What is not right is that fact.
My lord, council is confusing Director of Medical Services of Uganda Police with the person heading the city mortuary.
Dr. Ozivuwa, who is heading the city mortuary today?
Today, I don't know.
When did you last know the head?
I don't know, we need to record.
We need to write, okay, I will slow down. When did you last know the head of the city mortuary?
No, not when I left.
Okay, so by 2023, who was heading it?
In 2023, I said, that's when I left.
Yes,
There
so
were radical changes in that mortuary.
my question is being clear. Mr. Katanga, we have, Dr. Ozivuwa, we have about several questions for
Yes,
you. So
that's
please, you will do this court a favor by answering directly so that we know.
Okay.
You say you last knew the head of the city mortuary when you left. And this court has information you left in December 2023, right? So by that time, who was heading it?
My lord,
Do you know or you don't know?
I retired in 2023.
Yes.
That does not mean that I know what was going on in the city mortuary after 2013.
So did you last know the head of the city mortuary? You know, that's the question where it came from.
I said, my lord,
When did you
don't
last know?
I knew myself in 2013 when I
So-
was the head.
So from yourself, you know no other head of the city mortuary. I want to leave this point.
That's right.
Okay. That you, if you ever headed this place at all, my instructions are otherwise, but you never handed over to any officer from what you are telling court.
No, I didn't hand over.
You just marched away.
I didn't march away. We were chased away.
The city mortuary since which year were you chased away?
2013.
2013. Will I be correct to say that you don't know how that place operates since 2013?
No, my lord.
You have no idea who works there and how they work.
My
Do you?
lord, I don't have any formal information to that effect.
So is the answer that since 2013 when you were just away, you don't have any information?
That's right.
As to who works there and how they work.
Yeah, I don't have any formal information.
I'm not going to ask you for rumors. So, I will restrict you to what is formally in your knowledge. So when you said this place has the endemic problems, and all the rest that you characterized the workings of this city mortuary, you are referring to the period when you worked there.
I am actually referring to the period after I left there. Not only me, but the senior pathologists.
Talk about yourself. You are the witness in court.
That's right, but I know my colleagues were also chased.
You were chased from the city mortuary because you were among the group that was not formally established there. You were passing out and you were there without any formal instructions. That is why you were chased out of that place.
That's not right, my lord.
Dr. Ozivuwa, do you hold any formal instructions? Do you have any formal instructions that placed you or assigned you to do any kind of work at that government facility?
That's
Do you?
right. Yes, I do.
Which one do you have?
My appointment letter is a pathologist.
No. I'm referring to assignment of duties at the city mortuary. Please kindly, Doctor.
Yes, I did at that time.
Which one did you have?
The timetable that was produced by the Department of Pathology. My Lord, I want to tell the reality.
My Lord, may he be advised to tell this court the reality about him, not other people.
Objection, my lord. I think my colleague can only is at liberty to answer questions, including others. But you can't limit him and say your answers should only limit to you. He wasn't working in the forest. He was working with others. So I think my lord,
we're asking the witness about him and what he can verify. The others are not here.
My lord, can I finish? Can you, my lord, uphold me a minute finish? Thank you, my lord. So, my lord, my colleague can determine questions to a witness. He cannot determine the answers, even when he doesn't like those answers. When he asked Dr. Ozivuwa and said, how are you working in Mulabu? And he says, that's how I used to work with Dr. So and so and Dr. So. You can't say, no, don't mention those doctors. And at the same time, ask him about other doctors, Garogawa, Lungi, and everybody. You can determine your questions, my lord. You cannot determine the answers the government gives.
But in this instance, Mr. Tumebase, they're asking him about his posting instructions.
Yes,
let him talk about his posting instructions. When the question requires him to talk about others, that is how the question will be. They asked him, do you know Dr. Barunji? Do you know Dr. Biaranga? On this one, let him talk about his posting instructions.
Yes, you see, my lord, what I am avoiding is for the witness to be given a tunnel within which to walk. You can't say, don't say this, but say this. Let him say what he wants to say.
Mr. Tumebase, the witness will answer the question on his posting instructions.
Because he wasn't working in isolation.
But they asked him, do you have posting instructions? It is him who is giving evidence, not the others.
The who doesn't have a P7 certificate on it.
Mr. Tumebase,
so it's irrelevant.
please be seated.
Okay. I was imagining.
Dr. Ozivuwa, we shall now move to something else.
I am not a lawyer.
That's why I'm careful to ask you as a forensic pathologist.
I will need guidance, my lord.
My question is, do you know or you don't? I don't know what guidance you want God to give
Can you
you.
explain to him what subjudice is so that...
My Lord, may I request that he states whether he knows or not, then I will proceed to that enlightenment. My question is, I kindly listen to how the words come from my mouth. They are on purpose. Okay? My question is, as a forensic pathologist, do you know about the rule on subjudice?
I do not know, my lord.
Pending determination in court, it should not be a subject of public debate. Are you hearing this for the first time?
I understand this now.
You now understand it.
From you, yes.
Are you understanding something that has been in your knowledge as a senior pathologist, a senior consultant?
I have always known.
Okay. I want you to confirm that you are a member of a media platform called Pathologists Uganda. Are you?
That's right, my lord.
16 p.m. on Wednesday when you left this court, you posted your third opinion, what you call the third opinion, which is the PowerPoint presentation on that group, correct?
That's right, my lord.
What was the time again?
My Lord, 7:17. 16 p.m. I want an extract of what you posted. Can you go to the second page where you see your number?
That's right, my lord.
Confirm the time you posted it.
7:16 p.m., my lord.
What caption did you put to your PowerPoint presentation before this vote? Read it to court.
Yeah, this was the presentation in court today. A prudent doctor knows when to consult and when to refer.
You confirm that that is what you posted.
That's right.
Please give it to us. I pray to have it in as an exhibit.
My lord, we object to the tailoring of this document, and the rules of tailoring electronic evidence should clearly apply. While the witness has confirmed that that is his phone number, the person who took this picture should be here. The phone, and we examine it because of the possibility to insert. So you don't take a screenshot of the message I sent to you and pass it on to a lawyer, and then the lawyer brings it to court the following morning just because I sent you a hi. The phone should be before court. We should be able to cross-examine them. Not he's on a professional group. They were discussing the messages I see. They were discussing his day in court and advising each other as doctors, as pathologists. It's only allowed in Uganda, that's how it continues. So my lord, whoever, those other messages, when you put this in isolation, you don't get, the entire conversation is very good. Actually, it seems to be a very interesting discussion between these pathologists. Very nice. But my lord, the rules of tailoring electronic evidence witness is not the best witness to tailor it in. Is not the author. There seems to be about 10 messages on these pages. There are 10 messages. Dr. Ozivuwa only has one. All the others are by other doctors. My lord, when you read section 8.2 of the Electronic Transactions Act, it says a person seeking to introduce a data message or an electronic record in legal proceedings has the burden of proving its authenticity by evidence capable of supporting a finding that the electronic record is what the person claims to be it.
Just a moment.
For it to
Seeking to introduce a data message on
legal proceedings has the burden of proving its authenticity. So we don't know whether this was printed from my colleague Mwaganya's phone or not. Its authenticity by evidence, so you prove by evidence, capable of supporting a finding that the electronic record is what the person claims it to be. So we will need evidence to prove that this is what my colleague Mr. Mwaganya claims it to be. So we can't just have screenshots, my lord. So we can't even know, my lord, and that's what is important, whether the person who passed on this one to him is on the group. We would be happy is on that particular group of pathologists, Uganda. If we get the person who passed on the message with his phone and we have him, then that's, my lord, very good. Because I like the discussion. It's very professional. It is informative. It tells us that there are only 3 people allowed to do autopsies in Uganda, only 3. But now we don't know. So we don't know whether it's by a hacker. Some hacker could have hacked into the pathologist group and inserted some messages. We don't know. But fortunately, the witness has accepted that when he left, he shared his finding with his colleagues in a professional group. So when he has gone over the head of that section, then, my lord, we can consent to it, and then we even re-examine our witness on it. You must first go through the head, proving them we saw. The DPP's office. We seem to be witnessing a crime being committed in court now. I don't know who will charge him because he's the one charging people. But, my lord, we seem to have a crime. We are in the middle of a crime scene now. Data message or otherwise has been passed. Assessment in terms of subscription to, and that the information is capable of being displayed or produced to the person to whom it is to be presented. And 2, for the presumption of section 2, the authenticity of the data message shall be assessed A, by considering whether the information has remained capable or unaltered, and then B, in light of which the information was generated. In light of the purpose for which the information was generated, that is B. In light of the purpose why Dr. Ozivuwa generated this and sent it to his first group, WhatsApp group of pathologists. What was the purpose? I'm much obliged, my lord.
My lord, we shall restrict our reply. What is being sought to be tendered is a document, not an electronic message. Once a message is printed and reduced into a document, it ceases to be electronic, becomes a document. It ceases to be a data message, my lord, I beg your pardon. It ceases to be a data message and it becomes a document. And so the rules then govern, the rules that govern the tendering of that exhibit cannot be the Electronic Transactions Act, but rather Evidence Act. So with due respect, the section 7 and 8 being quoted by Learning Council are inapplicable. My lord, under the Electronic Transactions Act, section 2, which is the interpretation section, defines a data message to mean data generated, sent, received or stored by a computer. And may include voice, where the voice is used in an automated transaction, and stored record. My Lord, we are not seeking to tender a data message, either voice or a video, or a message still stored in a computer. We are seeking to tender a document in its physical form. My Lord, it should be noted that all documents are first generated through electronic devices, which are otherwise called computers. But once a document is printed out, then it ceases to be electronic. It becomes he posted on that particular platform. It has not denied or casted any doubt either regarding what he posted or the accompanying captions. He has not even insinuated, as counsel seems to submit, that anything was inserted or that anything is incorrect. To that extent, my Lord, and this being cross-examination, the document should be accepted on record. And in this case, my Lord, not necessarily to prove the content per se. It's not about content, but proof of the fact that the witness posted the material on a particular platform. It can only be him, my Lord, to confirm or dispute. And he cannot confirm, and there exists a justifiable reason to reject admitting it on record. We so pray.
My Lord, just a brief rejoinder.
My Lord, he has no right to rejoinder.
We objected
The application
to tender a document, this and not an electronic message. He said, I intend to tender a document, not an electronic message. And he went to the definition section of the ETA, the Electronic Transactions Act.
Mr. One, they intend to tender.
He says he intends to tender a document, not an electronic message. That was his opening statement. And then he went to section 2 and read the definition, that is the definition section, my lord. He read the definition of data message. My lord, our objection.
He can only rejoin on what we have submitted. But he's introducing new matters.
My lord, this is the definition section 2, which he read. I'm on section 2.
Definition, isn't it?
Yeah, it says it, my lord. I'm just reading for you the definition. No. The Transactions Act, my lord, you read section 2. You read section 2, the definition. No, it's not system, it's electronic record. Not system, my lord.
Transaction Act section 2 defines that data message mean data generated, sent, received, or stored by computer and the
I only restricted myself to electronic data, not systems.
No, my lord, I said, my lord, sorry, I'm not going to systems.
where the voice is used in an automated transaction and stored.
And my lord, I'm within that same section 2.
Section 2, and you're talking about electronic
Record. And my lord, I'm saying our objection was on electronic record, not electronic message. And I am going to the definition section because he read one part and then to go to the other. And the electronic record in that definition section is defined, it means data which is recorded or stored on any medium in or by a computer system or other similar device that can be read or perceived by a person or a computer system or other similar device, and includes, I wrote underline, display, printout, or other output of that data. The printout, this. So that is the definition of the electronic record in that same section 2. It includes printout. It means data which is recorded or stored on any medium in or by a computer system or other similar device that can be read or perceived by a person or a computer system or similar device, and includes a display, printout, or other output of that data. Output of that data. Whichever way you output that data, computer record. And then section 6, I mean 8.
More debate.
Generated more debate. Doctor, had you engaged in the so-called previous debate on the matter?
That's right, my lord.
When was that previous debate on the subject?
Can I look at my phone and tell you?
Yeah, I think my lord does. Yeah. And I'm asking when? But even without the dates, my lord, what I intend to find out, doctor, is you to confirm to court that the previous debates were before you came to testify in this court.
That's not right.
Oh, it was after?
Immediately after I testified, the debate started.
Okay, so the debate started when you testified.
That's right.
Okay, then that's okay. You can keep this with your phone.
Okay.
As a doctor, are you aware that your professional conduct is governed by laws and the professional codes of ethics?
That's right, my lord.
Is it in your knowledge, doctor, that your professional code of ethics prohibits disclosure of information relating to your subjects, unauthorized disclosure of information relating to your subjects?
That's not right, my lord.
So you, as a doctor, you are at liberty to disclose information of your subjects. Are you or you are not?
That's a misleading question, my lord.
Let me repeat it so that I'm sure you are. As a doctor, are you at liberty to disclose information relating to your subject?
Yes, but when it is a matter of court, you can disclose.
To whom do you disclose matters of court? Is it to the court or to the public?
To your colleagues and to court.
Are you in position to guide this court as to the specific court which authorizes you to disclose such matters to your colleagues? You are a senior person.
My lord, we don't see...
Are you or you are not?
Again,
For report.
Yes.
Asking for report.
Yes. Are you in position? My question is: are you in position to guide this court to a specific court that authorizes you to make such disclosure to your colleagues?
no, there is no specific court.
There is no specific court. With your indulgence, my lord, I request to read these provisions and I put the concluding questions to the council. Please listen. It says, subject to subsection 5 and section 30, a health worker shall respect the confidentiality of information relating to patients or clients or his or her family. Such information shall not be disclosed to anyone without the patient's or appropriate guardian's written consent by law. Do you feel bound by that provision?
Definitely.
I'm also reading you section 30, subsection 5, which was referred to, and says a health worker shall respect the confidentiality of information relating to patients and his or her family. Such information shall not be disclosed to anyone without the patient's or appropriate guardian's consent, except where it is in the best interest of the patient.
I agree with that, my lord.
I want you, in addition, to confirm to this court that you are bound by the Uganda Medical and Dental Practitioners Council Code of Professional Ethics. My lord, it is the Uganda Medical and Dental Practitioners Council Code of Professional Ethics.
That's right, my lord. I'm bound by it.
Or in the case of a minor, with the consent of a patient or guardian, or in the case of a mentally disadvantaged or unconscious, or, and I emphasize, deceased patient. In terms of deceased patient, without the consent of his or her authorized next of kin, you are prohibited from disclosing information of those subjects. Is this something in your knowledge?
Yes, very much.
Photographs of a deceased man called Henry Katanga on social media. Did you have this required consent from his next of kin? Did you or you did not have?
No, I did not have.
Will I therefore be sure that your action was of displaying these photographs in that report was unethical, since you did not have that consent?
You are very wrong, my lord. He is very wrong. Because the late was neither my patient or a deceased I worked on. So this, you cannot hold me responsible for that.
When you get your qualifications, you register them with the Uganda Medical and Dental Practitioners Council.
That's right, my lord.
In fact, qualifications of all licensed medical practitioners like you are published for the entire public on the official website of the Medical and Dental Practitioners Council.
I don't know that.
Are you aware if I wanted to get your records, it is possible to search your particulars on the platform of the council?
My lord, I don't know how accurate those records are.
Do you doubt the accuracy of your regulator, the information provided to the public by your regulator?
I have no reason to doubt it.
You have no reason to doubt it. I want to search for your record, and my requirement is that you confirm to court whether that is a true reflection of your standing in terms of your professional qualifications.
That's right.
My lord, may I request the...
Now what we are doing is that we are putting out those records that the witness has already said, I don't know how accurate they are. Said, I have no doubt, I have no reason to doubt them, but I said, I don't know how accurate those records are. And now we are putting them out for him to confirm that they are accurate or not, when he has already said he doesn't know how accurate they are. So
Of the website.
Yes, ma'am.
His regulator.
Yes, ma'am.
And the witness is here.
Yes, ma'am.
He has said he cannot know whether they are accurate, but he has no reason to doubt them.
Yes, ma'am.
That's not
Right.
anyone can go to the
space, council, council like the council, not like Mr. James. No, the other council with the C. No, C. No. I-L space S. When you do that, you go and start typing. Ms. Ozivuwa, how do you spell your name in your records?
O-N-Z,
Or you go slow.
O-N-Z-I-V-U-A.
Space. The other one?
Sylvester.
You can even search by Ozivuwa. There are not many Ozivuwas in that council. Ozivuwa. Add Sylvester. So who are you? S.
SY L S T E R.
Yeah, enter. Let's search. Go down. You are searching in the AI. I want, but that we shall still find it. Go down, go down. Okay, click on find health practitioner. Go to, no, go up. UMDPC, no, there. There where the cancer is, not down, there. Choose that. Now go to that search area. Put in Ozivuwa Sylvester. UA. Space. Put Sylvester.
Yes, SY.
SYL.
Yeah, it's the other way.
Yes, SY.
SYL.
Okay, Dr. Go ahead and join him.
SYLVESTER. Sylvester Stallone.
Just type in. Other things will come. You never told us you had additional names.
No, just to help you to spell it.
Sylvester Stallone.
I like his confidence. Thank you.
Can you remove Sylvester first?
Let's go professional.
Just search on the phone. Can you characterize for? Search. Maybe you close and begin again. I wrote on my laptop is clear. Or you start, Mr. Attendant, start with Sylvester. Start with Sylvester on school. If he has no data, my lord, we shall use the wanted platform for all of us to follow. Doctor, is that you?
Yeah, that's right.
And this is your regulator.
That's right.
Look at your qualifications. They reflect your true academic standing as filed by the regulator. Take your time.
Mr. Morgan,
Yes,
one
ma'am.
of the assessors.
Oh.
nga daktari omutendeke ayina baina ekitongole lundi baina ekitongole kyomusobozi ekibakuura kandi haliho ebintu ebimu ebitaikirizibwa bokolebwa nabantu abandi bona bajja okuyaho akusanga wakiba kiri ekintu ekiri kyamateeka bakusobola baikirizibwa nti okusobola kugambiraho bagenzi bawe rundi okugambira olukala lwamateeka bati kandi busaho olukala lwamateeka lwonna olwikiriza olwamanyire olwokumwikiriza kukola ekintu nkekiyakozire obuceeka mu kitabo ekyohereza obusobozi olundi ekibakuura nka badaktari kuceeka ka 33 akakusatu rundi akasatu akuteeka ka namba 5 abimanyire baitu tabimanyire mu mutwe baitu kandi nakimanya nti nibimukwataho kandi nibyo bimukugirira rundi nibyo bimuhereza ekiwukurwa kandi okumugamba nti kino kiyakozere nti akacekiragiro agambire nti tikiri nikwo ekyo tikiri habwokuba omugenzi Henry atabe mulwaire we rundi atabe muntu weena obu yakozere obwo kandi nti obatunga okwegesebwa kuwona bakuhandikisa omu kitongole ekyo ekibakuurabo nk'abajanjabi kandi nawe ebihandiiko bye byona ikaina bihandikisa kandi hano hali tuli tukwolekebwa obutendeke bwe alutimbe olukooto
So Dr. Ozivuwa, part 3 is your qualifications for the record. You can see them, but you have to be on record. My Lord Assessor is back.
My Lord, Bachelor of Medicine and Bachelor of Surgery of Makerere University, 1990. M.Med means Master of Medicine of Pathology in 2003. The other one is Diploma in Forensic Pathology, postgraduate diploma in Forensic Pathology from the Colleges of Medicine of South Africa in 2005.
These 3 makes you a forensic pathologist.
The last one, my Lord.
The postgraduate diploma in forensics, but to verify the authenticity of your documents before publishing them?
I am not the regulator, my lord. I don't think.
Okay, I want to sample maybe one more example so that we can compare you and what other results by other people. You want to volunteer who we should sample? Okay, let's sample your friend William Mutumba.
That's right.
Type in William, the one who did the post-mortem report that you reviewed.
That's right.
To read the qualifications that are displayed that he possesses.
That's right, my lord.
Okay. What does he possess?
Bachelor of Medicine and Bachelor of Surgery of Katanga University, 1984. Master of Medicine Pathology of Katanga University of 2005.
And you consider Master of Medicine in
Pathology
Yes.
of Katanga University, 2005.
Yes.
Then Diploma Forensic Pathology, College of Medicine of College of Medicine of South Africa.
Which year?
I can't see what.
It's clear even in the blind can see.
Our eyes, right?
Okay.
Can I move
Sure,
closer?
sure.
Yeah.
But it is expanded for you. So, doctor, from an academic point of view, do you possess any superior qualifications than that man called Malem Tutu? Qualification for being a pathologist, you are both trained from the same college.
That's right, my lord.
I just wanted to correct the impression that you had, I believe, inadvertently caused, referring to that gentleman as the less of a pathologist.
That's not right, my lord.
Of seniority. Dr. Malem is more senior to you. He started practicing medicine way before you became a student of medicine. You qualified in 1984. You qualified in 1992.
That's right.
I now want to do one more thing. Dr. Ozivuwa. Are you familiar with, again, let me save on the time. I want to read you regulation, Dr. Ozivuwa. This is what it says. It deals with professional reputation of colleagues. I believe you know it, you knew it even before coming to this court.
That's right.
A practitioner shall not on the probity or professional reputation or skills of another practitioner. the practitioner shall not unjustifiably cast doubt on the probity or professional reputation or skills of another practitioner. You were in this court last Wednesday, Doctor, and you imputed the professional standing of that senior gentleman. Having brought regulation 22 to your attention, do you regret your imputation?
Absolutely not, my lord.
Lord, again, I will leave that point at that and move to another subject. May I pray that my Lord, the laptop is available if Mr. Kaweka can't afford one.
This is the one which council has used.
My Lord, I know Mr. Kaweka is not, may not be IT compliant, but what has been displayed there is not a laptop. It is information from a website. But the laptop is available, my Lord.
I already used the first one and it failed.
We shall use this one. That's what I'm saying. Yes. My Lord, I pray for very first report that you issued, your first opinion that you can you read to court the first?
I acknowledge.
No. Paragraph number 1.
Supposed to read the first sentence?
In paragraph number 1.
Oh.
Yes. Up to the word and, then you end there.
The body of the late Henry Katanga was brought to the Kampala capital city mortuary in a private vehicle.
Proceed up to officers.
And not a police vehicle, or accompanied by investigating officers.
And end there. The postmortem report is passed over to the witness. We could use the one he used, my Lord, which is BE 22. That he worked with. In the report that you possessed at the time of making this report, not accompanied by the investigating police officers.
My Lord,
Is it there?
there is no investigating officer noted here to accompany the body.
Okay. So will I be correct to say that this is extraneous information that you got from other sources, not the report that was before you for review?
No, my lord.
What is the source of this information that you got in your report?
My lord, this postmortem.
Okay, take quote where you got that information in the postmortem report. Forget about the vehicle, just go to the fact that the body was delivered to the mortuary, not accompanied by any police investigating officers, as should have been the case.
My lord, it should have been recorded here which police officer accompanied the body.
It
should have been recorded.
Have been recorded. Not recorded, you confirmed it as a fact that it was not the case. Is that what you want to tell this court?
No, my lord.
So what informed your conclusion? You are making a statement of fact in your own report. What informed your mind to arrive at this statement of fact?
A post-mortem report.
Where?
My lord, there is no name of a police officer accompanying this body.
Exactly. So please kindly understand my question.
Yes.
So because there is no name of a police officer who accompanied the body, that is what informed your conclusion that there was no police officer. You notice that this court already has evidence of which police officer accompanied the body. Do you regret that you made an incorrect statement of fact as a professional?
From the post-mortem report, I could not have done otherwise, my lord.
Does the post-mortem report indicate that no police officer accompanied the body? It has not, my lord.
Because he said that the post-mortem report did not indicate which police officers accompanied. I made the conclusion that no police officer accompanied.
Will I be correct, Dr. Ozivuwa, to say that simply because the post-mortem report didn't mention that fact, you assumed that there was no police officer?
My lord, I could not assume otherwise.
So you assumed?
I could not assume otherwise.
Okay. That is still fair. It's correct to conclude that your report also contains assumptions.
My lord, maybe let's be specific on which assumptions.
Okay, you will tell court whether which specific assumptions, but does it contain any assumptions?
Not any more. Not any that I'm aware of.
Apart from?
Not any that I am aware of.
I want you to go to paragraph 2 of your first report. Paragraph.
And Dr. Ambayo Richard who are well known to me.
How did you conclude that paragraph? Read the last sentence.
I know for a fact that the two ex-pathologists have no specialized qualifications in forensic pathology.
Read it again. You know it for a fact.
I know for a fact that the two pathologists have no specialized qualifications in forensic pathology.
Doctor, with what you have just informed this court in respect of Dr. William Male Mutumba, do you still maintain that this, your conclusion in respect of Dr. Mutumba, is correct?
To the best of my knowledge, yes.
Just to remind you, a few minutes ago, you told this court you hold no superior qualification than those of Dr. Male Mutumba. Do you still hold this view at this moment in time?
Of course, with respect to forensic pathology, I still have question marks, my lord.
May I know under what authority you have question marks? You have question marks as who?
My lord, I told this court,
If you
I
can-
coordinated
If you can
the
answer
training.
directly.
Yes, as a coordinator of that particular course that Male Mutumba went to attend in South Africa.
Coordinated the course on
The forensic pathology. Mutumba attended in South Africa. Of that group that went, two pathologists did not qualify. That time, two of the pathologists that we sent to South Africa did not qualify.
Okay, so Dr. Ozivuwa, good enough. Were you any of the instructors of that course?
Yes,
Were you or you were not?
I was.
In South Africa?
No, they started here.
No. That qualification you read to court is attained in the College of Medicine, South Africa.
That's right.
Yeah. Maybe you are mistaken. I'm talking about what you read. He studied from the same college that you went to in South Africa. Were you any of the instructors in that university?
My lord.
Were you or you were not?
Yes,
You were one of the
instructors.
in that university.
I think you don't understand, my lord.
I can assure you that I do.
No. Maybe I need to clarify.
No, maybe.
South Africa. It's not one college. Colleges of medicine of South Africa.
That's right. That's right, doctor. So thank you for the clarification. Were you any of the instructors or teachers or professors in that university?
Yes, my lord.
So you taught this gentleman in that university and he failed.
The teaching, yes, he failed.
Did you? Yes, please.
Yeah.
Did you teach this
Yes.
man in that university?
My lord, for clarity.
In that college? My question
Yes.
is clear, Dr. Ozivuwa, please.
That's right. I would like to clarify.
Did you teach him in that colleges of medicine South Africa? This is simple, please.
My lord, can I say how this course was
Please,
conducted.
in South Africa.
There may be the witness give us a bit of a background about his
My lord, I don't require the background in this question.
My lord, the court
I am
has to read, my lord.
Yes, the court will, but my question cannot be modified by Mr. Tumweva.
No, the court has.
No, my lord, I won't allow that. I'm sorry. I am not.
asking and saying.
My lord,
So
we
I
shall.
wanted to know how it works so that we understand.
Yes,
We need to write the respect in which
That's what we agreed to.
give a bit of clarification.
Please.
How the-
My lord, I am most obliged. These people won't answer for Dr. Ozivuwa. Dr. Ozivuwa, please answer what the court is
said you
requiring.
are going to buy
Mr. Tumweva.
Much obliged.
My lord, I designed Makerere to do the initial teaching, and the students would only go to South Africa to do the practical part of the exams. The first part they will did here in Uganda. So here I was their supervisor and their teacher. This was in collaboration with the colleges of medicine. They made.
So you designed the course.
I designed
It
the
was in
course,
two parts. Part of the training was in Uganda.
right?
The other part was.
And my lord, that's how I ended up teaching them. And when the results came out, they were put on the website of the colleges of medicine of South Africa. That's how I knew Malem Mutumba did not qualify.
And which year was this?
This was in I think 2012,
When did you get yours?
2005. The results are still there for the web. We can show it here, whether he qualified or not.
Now, Dr. Ozivuwa, just a simple thing. By the way, even what you requested is good, and don't mind, we will afford you that. This court would be interested in knowing, were you part of the decision makers in the College of Medicine in South Africa as to who to qualify and who not to qualify, or you just had, or you were told that your colleague did not qualify?
On the website, where the results are displayed, his was there.
You just saw it on the website.
That's right.
And on the website, then that is what led you to assume that he never qualified, correct?
That's right, my lord. I am not.
So just to remind you that you made in this report. We are now going to the third one. Read the third.
Error in the identification of the entry and exit gunshot wounds.
Proceed.
Gunshot entry and exit wounds on the skull are identified by beveling effect of the bullet on the skull. This was not mentioned in the report, and probably not looked for and documented.
Now, your closing remarks in this paragraph, you are talking about the probability of your colleagues not looking for it. Just to confirm to court that this is not a finding backed by evidence, but it is an assumption.
This finding is backed by the post-mortem report.
What in the post-mortem report backs this finding? Go straight.
Beveling was not mentioned.
Again, because beveling is not mentioned in the post-mortem report, you assumed that it was not looked for by your professional colleagues who authored that report, correct?
Such an important
Correct or not?
Such an important thing.
Is it the reason why you assumed? Please, doctor.
Yes.
Okay, please, let's move.
Yeah.
We don't want to keep you here for so long. We want to move very fast. So that is the third assumption in your report. We are going to another one. Please, doctor, go to the fourth paragraph.
No doubt. There is
that is number 5. You go to number 4.
of the entry and exit wounds should have been identified at the post-mortem examination and then swabbed for gunshot residue. There is no record of this having been done.
You appear to testify in the High Court. Correct?
That's not right, my lord.
How many cases of gunshot to the head have you ever testified in?
My lord, a Godi case.
How many? I'm looking for a number, doctor. Don't volunteer too much. Answer my question.
I don't know how many.
So the answer is you have testified in several cases.
In several cases, yes.
Gunshot injury
Yes.
to the head.
The Godi one, yes, the one with the head.
You want to, because this is a public record, you want to go and record that Godi case was gunshot to the head? It's a public record.
Yeah, my lord.
Do you want to go and record
Yeah,
that
that's
the Godi
true.
case was gunshot injury to the head?
There were 2 gunshot wounds. There were 2.
Was one of them to the head?
Right.
I'm not conceding that it is correct, but it is on record. Okay? So I don't have further much, my lord. Godi case is a public record. We traversed it. So other than that, do you remember any other in your entire career?
My lord, I need to think backwards.
So you can't remember any other?
I have done too many postmortems.
Dr. Ozivuwa, do you just remember on Thursday you told in this court that you only had an opportunity to testify once in the court martial and not in the high court? Is that something that is fresh in your mind?
My Lord, I say I don't remember. My words here were clear, I don't remember. When I went back, I reflected. Yeah, on Wednesday.
You said you don't remember
I
what?
didn't remember other gunshot injuries that had handled in high court.
Okay.
But I remember one I handled in the military tribunal. Yes.
So when you went back, doctor, you reflected and you remembered only the body case.
That's right.
Was it therefore a finding of scientific fact, or it was an assumed fact due to absence of information in the postmortem report?
My Lord, it was due to absence
It was
of
assumed
information.
due to absence.
Of information, yes.
That you are making.
They are not assumptions, my Lord.
Are they facts?
They are facts, my Lord.
Now, read to court paragraph 5.
As demonstrated by the powder blackening, as well as the blast effect of the gunshot that caused extensive lacerations of the outer aspects of the right ear.
Doctor, you will agree with me that any person would only make this conclusion that you're making either by looking at the physical body or by looking at the photograph.
That's right, my Lord.
I just want to remind you, my good doctor, that by the 3rd of July 2024, when you wrote this report, you had no idea about the photographs. They were given to you a year later by your own testimony. So, that being the case, what was the source of information in this particular paragraph?
My Lord, at this point, there were black and white photographs that had been, I think, supplied, something like that.
Please, I advise you not to think. No, by thinking, not that you should not use his head. But this is not, my Lord, this is not a speculative process. That's what I mean. Please, doctor, you are a witness. You are a witness. Please, Mr. Jet, please, let's not go there, please.
When the witness supplies an answer, even when you are uncomfortable, you accept it.
I have accepted it.
Yes,
So I
you don't advise the witness to
Doctor, I am advising you kindly that you are a witness of fact in this court.
That's right.
Not assumptions, not guesswork. Don't think. If you know, you know. If you don't tell this court. So, let's now proceed from where you ended. So, by this time, there were black and white photographs. Is that your position?
I don't remember exactly
where you got this information?
What informed me at this time of this.
You don't remember. A proper basis.
That's right. That's right.
But you do not remember the basis for which you made the conclusion in paragraph 5.
Yeah, the facts which informed this.
The facts.
Yeah.
Having in a black and white photographs.
I don't remember I don't remember really whether I had them or you have them.
Do you remember whether you had them at all?
That's what I'm saying. I can't remember.
Can't remember. Doctor, we were here on Wednesday and we advised you to carry your 2 bulk files that were given, because those will actually enable you to recollect.
Yes, my lord, I have them.
You have them?
Yes.
You think they can help you to remember whether you had or you did not have? Because that is your engine for this report.
Yes. My lord, at that time,
Now, my lord. Now.
They cannot help me. No, because I made this report before.
Before you got the files?
I got the files.
Oh.
It is extremely rare for a bullet that has been randomly fired through the skull to exit precisely through the ear. The compass.
Just read it again, Doctor.
It is extremely rare for a bullet that has randomly been fired through the skull to exit precisely through the ear. The compass, however, is very common.
Where did you get the information that the bullet that you were dealing with was randomly fired?
My lord, this is common sense.
You used common sense. Okay. Yes.
My lord, science is based on common sense.
And in this case, you used common sense. Yes?
Right, my lord.
I'm putting it to you, doctor, that by the time KAA comes to report, you were briefed of a case theory that people were fighting in a room and the bullet accidentally got discharged. And you were working through that theory at the time.
My lord, that is speculation. We object to that kind of question. They are inviting the witness to speculate and my colleague is speculating.
My lord, I'm putting a statement of fact.
To confirm whether or not he had been given a story. All the
That
witness
theory.
has to say is,
Yeah. That theory was not there given to me.
Bullet turn from being a random bullet to a suicide bullet, which is a targeted shooting. At what stage did you change your mind?
My lord, I have never never said this was a hand operator. The right ear. Lead brain matter and bone fragments. I don't remember at that time where I got that information.
Was made for you, and your only job was to append your signature so that your credentials can be used to propel a specific defense theory. You never made this report, Dr. Ozivuwa, because if you had done so, you would know exactly where you got the information contained here.
I object very strongly. I have my laptop here. The report is here, made by me on my laptop.
There was a possibility of you imagining them and making reference to them.
My Lord, that is not true.
What is not true?
That I imagine these pictures in my head.
Did they exist before you when you are making this report?
My answer is simple. I do not remember the source where I got these pictures at that time. I thoroughly cleaned.
I don't know, ma'am. Yeah,
Precisely, that's my
I just told you about cleaning.
Yeah.
Depends on how thoroughly it was.
The body was cleaned. Yes.
So if it was cleaned very thoroughly, you would expect not to be cleaned.
You will not expect. But if it was not cleaned thoroughly, or otherwise, to confirm that the wound on the left temporal area was a close contact wound.
Yes.
The authors of the post-mortem report should elaborate on this.
The gunshot injury was close, near, or distant?
Why not? Should I read the
Please.
whole conclusion?
No. The second sentence. The court has the report.
Oh, okay. The gunshot was also a close contact considering the blackening of the right ear.
Okay. So the reason you concluded it was close contact was because of what you call blackening of the right ear.
That's right, my lord.
Okay.
And the lacerations, my lord.
Now, Dr. Ozivuwa, I just want to be clear. Do you believe that a bullet entered Henry Katanga's head?
That's right, my lord.
You believe that?
That's right, my lord.
And you believe that it exited?
That's right, my lord.
Read paragraph 11.
The bullet must have moved from right to left, upwards with a slight deviation backwards.
Okay. Hold it there. by use of the word must, doctor, this is confirmatory, done and dusted.
Right.
So by application of this word, you have no room in your mind of alternative possibilities.
Absolutely not, my lord. As shown here, to me, the entry wound was to the right, in the right ear. But the exit wound was above the left ear and behind it, above and behind. So this means that it moved from right to left with a slight turning at an angle, not a straight angle, not straight line, but a slight turning backwards. So that's what I mean by slight deviation.
Now, going with this body.
No, I did not.
You only dealt with the pictures, the photographs.
The photographs and the postmortem.
That those slight deviations backwards, it is.
My lord, the measurements.
You relied on which measurements?
The measurements in the postmortem report.
You relied on the measurements in the postmortem report.
That's right.
Okay. Authenticity of the measurements in the postmortem report.
I do.
They are accurate.
I do. Except, of course,
Are they accurate?
some are, some are not. My lord, in the postmortem report here, a wound was described as 3 by 5 by 3 centimeters. This was an absurd wound. 3 by 5 centimeters. S and X wound. Actually, I got around when I read this.
I don't think you're alarmed, but my question, so that you don't alarm us, my question is different. Where is the information that the whole ear was measured by anyone? Is it contained anywhere?
Yes.
Can you point to quote that particular part where you get the information that the entire ear was measured by anyone?
I demonstrated.
Is it there or it is not, Dr. Ozivuwa?
It is there.
Please point to read it to court.
Not in this postmortem report. My
Okay.
lord.
So where did you get it?
The pictures, my lord, which you sent. My lord.
Who dealt with the pictures were measuring the entire ear? Is that what you want this court to believe?
That's right.
Okay. Now, doctor, this is the final section of this, your first report.
My lord, it's a fact. When I signed this
I have not even come to signing, please. You were fully retired. That's all I want.
That's right.
Dr. Public Servant and public service standing orders were applicable to you.
My lord, working Uganda. She's not in, but she's in the bathroom, just out in the
She's
just the bathroom here. She'll be walking back from front, so she's not here. Just noticed when I walked in.
Yes, and bound by the public service, the laws applicable to public service.
That's right, my lord.
You may use the stool.
After it, you want to see.
There are the four of us where?
Incidentally, you are wrong, but then let me briefly take you there. But I will come to that, so let me not get diverted. Videos. In your medical practice, you are bound by the laws of Uganda.
That's right, my lord.
As a medical practitioner, you can only do that which is authorized under the laws of this country.
That's right.
Do you acknowledge that as a profession, the set legal standards way above your personal opinions or beliefs?
May I seek clarification?
Are your views or opinions superior to the set legal standards of the Republic of Uganda?
My Lord, I'm bound by the medical standards, not the legal standards.
Is it, in your knowledge, doctor, isn't it that every unnatural death in Uganda is by law a disputed death that has to be investigated?
I don't know that law.
Again, the reason I'm asking you here is the CV that you told this court. I expect that you're a forensic pathologist, and this is basic. This should be basic.
Yeah.
As a forensic pathologist, are you not an investigator of death?
That is right, my Lord.
So what don't you understand with the question? By law, that should be investigated.
That's not right, my Lord.
What is not right, Dr. Ngo?
My Lord, in this country, we investigate deaths apparently using the Inquest Act of 1936. But this has been overtaken by the realities of this investigation today.
Just a moment. We investigate death using the
Inquest Act,
inquest.
I think of 1936. But this Inquest Act today has been overtaken by the death investigation system.
What do you mean by death investigation system?
Ideally, by that law,
Death investigation system.
should be by an inquest.
No, I just want you to clarify to court what you mean.
Oh, okay.
This court understands the Inquest Act.
Oh,
What do you mean by death investigation system?
yeah. My Lord, there are 3 known death investigation systems in the world. There's the coroner system. Then there's the medical examiner system. And thirdly, there's the hybrid system. The hybrid system. Ours here has evolved in the hybrid system.
Are you aware of any other law other than the Inquest Act that authorizes you as a forensic pathologist to investigate death?
No, I am not aware.
So I'm correct to say it is the only principle law that the Republic of Uganda has.
The Inquest Act? Yes.
And you just told this court you are bound in your practice by the laws of this country.
That's right.
Okay. The purpose of post-mortem examination is to establish the cause and circumstances of death, correct?
And mechanism.
Those are circumstances.
That's
So-
not true. My lord, that's not true. There's a big difference between circumstances of death and mechanisms.
So your answer is that it is to establish the cause, circumstances, and mechanism.
Mechanism, right.
Correct. Subsection 1, it is provided that every medical practitioner, upon receipt of directions, in other words, request, shall immediately make an examination of the body with a view to determine from the examination the cause of death and to ascertain the circumstances connected with the death. Other than this law, doctor, as an expert, are you aware of any other law in this country that prescribes the manner as who and in which manner post-mortem examinations should be conducted?
No, my lord.
Answer was in respect to the pictures, please.
That exhumation and examining the skull with the doubts that you had would not have given you better conclusions.
I have no doubts, my lord. I have no doubts about my findings.
Do you understand that duty to mean that when you appear in court, you do not appear as an advocate to prove a point, but as a neutral arbiter to provide a neutral and a biased opinion?
To say the truth. I'm here to say the truth.
Did you find information about more than one projectile recovered from the scene?
No, my lord.
You never came across it.
I came across the pistol and
I'm asking about projectile.
I didn't come
More
across
than one projectile.
No.
And understood the Soko report.
I picked what was relevant.
You said you selectively picked what you wanted.
I selectively picked what was relevant to my report.
That presence of more than one projectile
No.
at the scene. Just a minute. Understand me.
Okay. That's all.
By the way, I'm not here to just make you tired to something. Yeah? So we are not adversaries. Just provide these answers. So you did not find that the presence of more than one projectile recovered at the scene was relevant to your determination.
That's right, my lord.
You never found it.
Not more than one projectile.
So what is the question? Are you asking
My lord,
whether
whether presence or recovery of more than one projectile at the scene was relevant to his findings? You never found that relevant to your findings.
My lord, I can just clarify.
specifically, sir, please, specifically, answer us specifically. These people are going to help you to clarify.
Yeah, my understanding of his question is that did I find information on more than one projectile? I said no. And that was very relevant to my postmortem, to the review of the postmortem.
Doctor, did you find information that the magazine as recovered at the scene had only 10 bullets?
My Lord,
did you find that?
That was irrelevant to my findings.
That was relevant?
Irrelevant,
Irrelevant.
to my postmortem, yes.
Irrelevant. Doctor, if you had focused, and I ask this because you said you had this report, and it is one of the relevant reports that you considered to arrive at your conclusions. If you had focused on evidence or presence of 2 projectiles recovered at the scene, what would have that spoken to your mind as a specialist?
Objection, my lord. Objection, my lord. I think my learned colleague is misleading the witness. Telling the witness that if you had focused on the 2 projectiles in the Soko report, that Soko report doesn't have 2 projectiles, my lord. At all. Just 1 projectile. The two things were later introduced by Bibiana. But the Soko report, if we can limit it, let him point us which paragraph talks about 2 projectiles. Was 1 recovered? And the witness has already answered. So my lord, that question is misleading.
My lord, I want to save on the time, not to go.
That, my Lord, I did consider relevant to my terms of reference.
More than 1 missing bullet, what would that have spoken to your mind?
I'll look for other wounds on the body.
Anything else?
As a forensic pathologist, no, I'll leave that for the ballistics.
So you would not even look for other wounds, you will leave it for the ballistics?
No, I said I'll look for the wounds on the body.
Yes.
But the magazine and the pistol were for the other team.
Ballistics?
The ballistics, crime scene, and so on.
The reason you would leave it for the ballistics is because that is not your specialized area.
That's right.
Operation of guns is not your specialized area.
That's right.
My Lord, may I request that the PowerPoint presentation be projected? What you indicate, these are also your teaching aids.
That's right.
They are not real case scenarios.
As you can really see here, these are teaching aids.
The simple answer would be.
Yes. Yeah. These are teaching aids. My teaching aids.
You don't carry specialized training. That all the information and explanations that follow now from page 2, 3, 4, please go to 5. 5, 6. Go to the next. 7, 8. Go to 9. No, up to 8. Up to 8. That is information dealing with the operation of guns. You have no practical knowledge about those aspects.
That is very wrong. The reason why a gun shot, the characteristics of gunshot wounds, that's the background. That information is so that somebody understands this wound is caused like that. So basics, my lord, basics.
Now, you see again, Doctor, I'm going to request you, sir, understand my question. You realize that my question is on practical knowledge. And then you chose to answer basics. I know both terms, please. Can you now answer as to your expertise in the practical knowledge application of the information that you disclose from page 2 to page 8? Do you have that practical expertise on operations of guns?
No, I don't have.
See how fair it is. Do you inquire or require any information as to the medical history of the deceased in the process of you arriving at your conclusions?
No, my lord, I didn't.
You are under the professional duty, as you confirmed, to review all material data. Would it have been helpful in your findings relating to the conclusions that you make as to his health status?
What I had was adequate, my lord.
Will I be correct, doctor, to say that your opinions about the possible health status of the deceased was based on information read from statements of third parties?
Statements the same, yes.
Not direct
No.
medical evidence as to their history, as to his medical history.
You're right, my lord.
Doctor, do you know who recorded those statements?
I don't know.
My lord, I'm referring to the police statements. Do you know who recorded them?
I don't know, my lord.
Is it in your knowledge that proof of content of police statements is a matter of law, not guesswork or assumptions? That's something you know or you don't know?
I don't know that.
You did know that. I can excuse you for that lack of knowledge. Did you interview the makers of those statements?
No, I did not.
From where you stand, are you in a position to tell whether what is recorded in those statements is authentic or not. By authentic, I mean true or not. Are
No,
you?
No, I have not. Question.
If you made any conclusions, therefore, based on that unverifiable, unproven, hearsay information from third parties, can you medically defend it?
Yes, I can medically defend it.
Will you be kind enough to tell this court how you can medically defend such unverifiable information?
One simple reason that I would have no doubts. I would not have any doubts as to why these people would be lying who made the statements.
So your position is that you are in position to tell this court that the makers of those, there is no possibility that the makers of those statements provided inaccurate information.
That's not what I said.
Lied.
That's not what I said.
Okay, what did you say? Let us understand.
I have no reason to believe why those people would be lying.
In other words, you believe that they told the truth.
That's right.
What is your medical basis for that belief? You are here as a medical doctor.
People usually tell the truth unless they have a reason for telling lies.
So as a doctor, did you exclude the possibility for telling lies in those statements?
Well, as far as the behavior was concerned, the statements were concerned, why not they believed them?
Lord, I will leave it at that. But please, doctor, you said you are under duty to avoid cognitive bias. What this means is that you are supposed to evaluate the entire evidence objectively, right? You are supposed to remain uninfluenced. Don't shake your head, speak. Okay. Just use the microphone.
Okay.
Yeah. You're supposed to remain uninfluenced by pressures of litigation and to stay free from premature theories. Correct?
That's right, my lord.
If an expert in your profession is found to have had cognitive bias, will his report be believable by court? Should his report be believable by court?
If that expert used 3 different methods, 3 different statements to come to that conclusion, sure, court would not believe it. Using 3 different statements from 3 different people, would court not believe that? I think court probably confused to believe that.
Thank you for volunteering, but I request you to answer my question. Do you remember my question?
Yes, that's the answer I think, the best answer I can give you, sir. My lord, that's the best answer I can give.
The test of steering clear from cognitive bias.
I definitely stayed clear of that. My lord, my report was very technical. And in many cases, the councils did not understand it. Wherever something little they did not understand, they would consult. So really, where is the bias? There is no bias.
Doctor, you have considered that if there is evidence of premature confirmation of premature theories, it is evidence of bias. I am reminding you that you arrived at your first report, Prosecution Exhibit 128, before the relevant information was available to you.
That's not right, my lord.
I will not pass it to you. Proceed.
The fact that I said I don't remember does not mean I acted, I was biased.
Doctor, the rest is for us to argue. Because cognitive bias is a mental element, isn't it? We can only tell it from circumstances.
Oh, no problem.
So let me... Yes, yes. Thank you. Votes. Do you disclose any specific scientific methods that you applied in this review? Tested, reliable, and definitive.
Yes, definitely.
Which ones do you reveal? Take this code to the page.
My lord, I'll go to the summary of my report.
The summary is born out of the main report, right?
That's right, my lord.
What's the main report? Let's begin with the main report. Do you indicate any before you got the PowerPoint? From
Yes, I did.
where? Which page in the main report?
My lord, on page 6.
What principles did you indicate?
Yes, the principles of gun or firearm injuries is what I detailed on page 6, page 7, page 8, page 9. These are scientific principles, my lord. Scientific principles upon which I made my conclusions.
Doctor, now let's go to the conclusion. What were you made conclusions in your PowerPoint? Files, you were at liberty, pull out that statement that you reviewed and got that information.
That's right.
Proceed.
Yeah, there in this part.
Put here, doctor, you can even use here. Use here, there's more space. It's okay. If you need.
No, Mr. Mwaganya, to
Not at all until now. The kindness is suspect.
Daktari atugambire mu bintu byonna okulugahala abantu basatu abokuba mu nkola y'okujanjabwa wonna mu kitandike kyakozeere okuyiyako akaba nakolerera amazima nahali ebiteekerezo ebyabantu ebyatungire kandi tumanyirwe ngu omugenzi ako akakiroraho ayina hali yakirozere wekujja kwegere kucwamu rundi kwetegereza nti omugenzi akaba nakozesa omukono gwe ogw'obulyo.
What's the statement, is it?
My Lord,
Use the microphone.
my Lord,
What's the statement, is it?
AIP of Lord John Paul. AIP of Lord John Paul.
Doctor, did you indicate that witness as the source of this finding?
My Lord, I did not indicate it here.
Do you know AIP of Lord John Paul
I do not know him.
personally?
No, I don't know him personally.
Did you interview him before confirming this, your opinion?
I didn't interview him, my Lord.
But you nonetheless believed him and included it as a confirmed scientific opinion. To consider exculpatory evidence or facts, right? Did you indicate any single material facts capable of providing an alternative theory to your conclusions? Did you or you did not?
I did consider it. The others were so remote that they were not worth putting in.
Consider any alternative?
Yes.
Yes.
Whether this was homicide or suicide, suicide was to be so high. Homicide was so remote.
Doctor, did you indicate even a single remote alternative theory?
Yes, I did.
And
Yes, I did.
where did you indicate?
Are we done with this?
Almost done, but you can close. Mr. We can be helping you as we say for the first time.
My Lord,
I was alive to other possibilities. But in my conclusion here,
I want you to take court to where you included the alternative theories, so that court can be sure that you were alive to them.
my lord, the conclusion just the one before, literature on IPP.
Slide 49.
Go to the conclusion. Conclusions.
It is the next one.
Go ahead. Go ahead. Go ahead. Go ahead. Yes, there. My lord. There is what I said. That this case is a homicide. I had homicide in my head. Is extremely slim, my lord, and highly unlikely. Points, I did not say concludes, I did not say points to suicide unless proven otherwise.
So, doctor, let this court understand you. Is your position that you had no doubt in your mind whatsoever that this was a suicide? Or your position is that evidence only points to suicide and there is a remote possibility of homicide? Which of those two is your evidence in this court?
Both, my lord.
It can't be both, doctor. It can't be both, my lord.
What are the options?
Yeah.
Mr. Morgan, what are the options?
You know, in his evidence, my lord, all through, he has been using the word, I have no doubt in my mind. I have no doubt in my mind that this was a suicide. And now, in the conclusion, he has just said, I did not say it is a suicide. I just said it points. Evidence points to suicide. So we want him to be clear now, under oath.
Yes.
Is it his evidence that you found conclusive evidence of suicide?
My lord.
Or that the evidence you found points to suicide with the possibility of homicide? Which of those two can this court take?
My lord, I think my conclusions here, to me, I have put them clear that the forensic evidence in this case points to suicide unless proven otherwise.
So, now, my lord, this is where I want the witness to be held to this court. What is that evidence in the postmortem report as is that points to suicide?
Could we go back to other slides? So that is because it's there.
That slide is not a postmortem report.
It,
Doctor, I am asking about postmortem report. What is that evidence in the postmortem report
okay.
that irresistibly points to suicide?
Yes.
Objection, my lord. If they strike off your head.
My lord, I'm asking about postmortem.
About the postmortem forensic evidence.
And I have no
Because
problem.
the witness pointed at it.
I have no problem with the
And my lord,
postmortem
because I am
report.
up, my colleague needs to sit down because I am standing up.
That postmortem
I'm up.
forensic.
I think that's what we agreed.
Yes.
Yeah, so sit down.
Mr.
Mr. Tumwebazi,
Yes, my lord.
the report states that the post-mortem forensic evidence,
Yes. And my
unless proven otherwise,
Yes.
was recorded to be a male. We know from the various studies that males are more common to commit suicide than females using a gun. The injuries were to the head in the post-mortem report. Injuries were to the head. Again, in the post-mortem, as I said, the head is an elective site. According to this post-mortem report, the entry wound was on the left, but I totally disagree that the forensic evidence.
You are still taking both the evidence of
Yes.
suicide.
Yes, that is it. That the entry wound was on the right, that lacerated ear, and came out through the left.
Is that in the post-mortem report?
No. What I'm saying is that I don't agree with these aspects of the post-mortem report.
Doctor, you are required to demonstrate to court where in the post-mortem report the conclusion of suicide is. Don't tell us about your arguments. We listen to them.
This is an erroneous report. So how does it point to suicide when it is erroneous?
So, in other words, if the post-mortem report does not contain evidence of suicide, is that what we understand you to mean?
Yeah, that
Yes
it is
or no?
erroneous. It is erroneous and therefore does not have that evidence.
So, post-mortem report, my word, let's be clear. So, Dr. Ozivuwa, it's bad, it's rough and uneven. Now, with that fact, will you still sustain your finding that the palm print must always be there? The palm print for the last user must always be there, in light of the fact that the history in this case, that its birth is rough and uneven.
My lord, a ballistic expert would probably answer that. I am not an expert in that area. I don't want to venture there.
So since you lack no knowledge, since you lack knowledge about the status of bats or grips of pistols, your conclusion has no finding, has no basis.
That one I will concede.
That
my
you
lord.
concede. Thank you for the first time you have conceded. I know that you must be a very lucky person this afternoon. Mr. Ozivuwa, what are you conceding? That your conclusion on page 7 confirm this court. That your report that you hold it in your hand has a lot of conclusions on gray areas that are outside your expertise. And that is the first. We are going to the second.
Okay.
Your concession has said we can follow 1 hour. So I've jumped the whole page. Do you know anything about DNA profiling?
Basic knowledge, my lord.
Basic
knowledge.
So you are not in position to even tell this court whether if faced with a scenario of a pistol bat or grip, it is best lift fingerprint or it is best to take a DNA swab? That you don't know.
No, my lord.
Do you also want to concede to your lack of knowledge on this particular conclusion? It is closely related to the first one. Dr. Ozivuwa, do you possess knowledge sufficient to arrive at this conclusion?
My lord, common sense.
Knowledge to arrive at this conclusion?
No, I don't. I don't have the technical knowledge.
Okay. This you cannot prove.
That's not right, my lord.
Okay, let's go to a third one. Let's go to a third one.
Ikihandiko kyakozere tugambire nti eky'enkumu ky'omuntu ayasembera